Yes, thank you, Mr. Chairman, members of the board. If you all recall, sometime in, since the fiscal year started in July, you approved and appropriated an attendant amount to cover your approval, a contract between the Office of County Counsel and the law firm of Coda Cole. And that was, with the support of the Health and Social Services folks, the contract that provides legal representation in the CPS cases. And I received notification within the last few weeks' time that the attorney that we principally deal with, and several others, employed with Coda Cole, have split off and formed their own firm entitled Prentice Long and Epperson. That contract, the initial contract that we had was, albeit with Coda Cole, it really was a personal services contract whereby we don't want to take the replacement lawyer out of Coda Cole. We want to stick with the lawyer, essentially, that we've been working with, who we think is very capable and is the primary attorney listed in what is proposed to be the new agreement. Now, ordinarily, if there's a change in a contract, we might come forward and ask that an amendment be done. But when you have new parties all together, you can't do an amendment. It's a new contract. It's a new agreement because the people, the players, if you will, are different. And so we are proposing to terminate the contract with Coda Cole early, and I'm asking for your authorization to enter into the contract for essentially what is the same service, one that you had already approved, with this new outfit called Prentice Long and Epperson, the attorney being Margaret Long, one of the partners in the new firm. I'll tell you that this does not represent, the only change, you already made an appropriation in this fiscal year. We're well within it. We've not exceeded it. We're getting good quality service out of Margaret Long on this. I've spoken with the folks at Health and Social Services. They're more than content with her representation in the CPS matters, and it's something that I think both from the department and from us we desire to continue. There is one change. The change is this. I changed the term. The term on the Coda Cole contract would have ended at the end of this fiscal year, June 30th of 2015. I proposed in the new agreement that it go to June 30th, 2016. I'm still confined by whatever appropriations you make or don't make. I have the ability under the first contract and this contract to terminate either of them on written notice. And so if the appropriation for this coming fiscal year doesn't come, I can deal with that on a moment's notice. I just didn't necessarily want to be back before you in 4 months' time asking for an extension. That was my thinking that went into that, and I'm asking for your approval and happy to answer any questions you have.
I would only suggest that if you have wording like that where you have a time frame that goes beyond the current fiscal year, which I think makes sense because it's an ongoing thing, just insert the language subject to available appropriations or something. So if all of a sudden you don't have an appropriation, the contract's there in terms of the service, but the funding for it, it acknowledges that they're not bound, you're not bound, and we're not bound. But I think that would be one way, and I think that actually makes sense with maybe a number of these kind of contracts, is to set a defined period but subject to the annual appropriations.
Aaron, do you have a question?
I do.
Yes, sir.
So is the rate on this new contract, is it basically the same? As
It is precisely the same. Yes, sir.
And how is that in relation to the other firms that do the same thing? Are they competitive or?
Well, this was a personal services contract, so according to the purchasing policy, there was no bidding process required. Ms. Vanderploeg had initially retained the services of Ms. Long through Coda Cole, and to be square with you, I was so dang impressed with her performance on those cases. She is effectively handling that caseload, that I did not go out and seek out additional bids. I'll tell you that with the amount of effort that goes into those cases, I view this as, I don't want to say a screaming bargain, but a bargain. Sir.
I think you'll find with most attorney contracts that these rates here are be on the low side of the scale.
You know, the benefit to a firm, of course, is that they have a contract in place, and it's, to a certain degree, assured income, where they don't know what's going to be walking in the door in the next 2 weeks. So there is some value to that for them, to have that stability. And so there is, I think, a discounting that occurs in that area. Certainly not on the quality of representation.
Any more questions? You probably. Okay.
Thank you, Mr. Powell.
Good morning.
Good morning. Agenda item H2 has been submitted by County Council. This contract is for legal services with Prentice, Long, and Everson. This contract is represented to you by County Council as a firm for Child Protective Services on a, what looks to be a consulting contract or consulting purposes. At least that's the language. However, on page 10, Council has slipped in an unusual clause for other services. Normally, when the county is sued, an attorney is hired through the JPA Trindle. I don't know if Mr. Hemphill is aware of that. The JPA, this JPA in particular, because I've spoken to almost everybody in the organization, has been a black hole of spending and secrecy when it comes to hiring attorneys for Lassen. They just pick a name out of a hat. There's no written contracts. You don't know how much you're paying for these firms. And this contract in particular is odd because I read, and our group reads, when a legal contract comes before the board to be approved, we print it, we hand it around, we hand it to our attorney. We look at it pretty close. And we have found that this clause that's been added in there is, in fact, unusual. The clause you'll see that we highlighted basically says that without having to do anything, other services, the law firm shall provide the following services to Lassen, including but not necessarily limited to the following. Represent the county of Lassen and any employee or elected official. Now this is a Child Protective Services contract. This is for consulting. And this, I don't know if you read any of this stuff, but County Health does. And it says represent county of Lassen and any employee or elected official of Lassen in any lawsuit filed or administrative proceeding regardless of where such action is filed upon assignment by Lassen. What you're giving Mr. Burns is the right to use this firm not only for Child Protective Services, which is presented to the public and you as why they need it, but it can also be used to protect you personally. And I have no problem with that if you're up front with it. If you're being sued all the time, it's public record on what firm is representing the county, and you have a lot through JPA. But this, I'm just telling you, this is an unusual clause. And it's going to be used. You've never hired a county counsel ever that was competent in litigating. It's always handed off to these little firms. And the public is never really aware how many lawsuits are against you. And it's unfortunate that the people sue you, and they lose most of the time. And that because you have unlimited resources to file a harassment case or a discrimination case or wrongful termination. You have unlimited funds. But this clause in this contract is odd because it's so easily, and I can tell you from the cases I've read and the contracts I've read on your legal services in, this will be abused.
Okay, thank you for your comment. Jim?
Mr. Chairman, if I could just comment, I don't find it